legislature and the states' rights advocates. The Court of Appeals was viewed as unionist and pro-abolitionist, and the legislature responded to the McCready opinion by abolishing the Court of Appeals in 1835, just 11 years after it had begun. Over the next 30 years, the legislature toyed with the idea of a Court of Appeals, and there were different versions that were in place, and they kept kind of changing. But ultimately, after the Civil War ended, an intermediate Court of Appeals was not written into the Constitution of 1868. Over 100 years later, in 1979, when the backlog of our Supreme Court was enormous, the legislature once again enacted a Court of Appeals. 5 judges were elected to serve on this modern-day Court of Appeals, and they were supposed to hear their first arguments in 1980. But there's a law that prohibits a state representative or a state senator from holding a position that was created by the legislature in which he sat, and 4 of those 5 judges that had been elected to the Court of Appeals had been in the General Assembly in 1979 when the legislature enacted the court. So those 4 judges were removed from the Court of Appeals, and a new election had to take place. Now, prior to those elections, the act was amended so that it would be a Court of Appeals of 6 judges, so it could hear cases in panels of 3. And a new election took place, this time without controversy. Finally, in 1983, October of 1983, our modern-day Court of Appeals heard its first arguments. A year later, the state constitution was amended to add the Court of Appeals, and this solidified our permanency and also protected us from the whims of the legislature. In 1996, our court expanded to 9 judges, which is the size of the court today. We're now in our 28th year, and we are so delighted to be here at Furman, and I thank you for letting me share the history with you. We're very proud of our history. This court has a legacy of upholding the rule of law above the passions of the times, and we strive to